So in this video, I have a very important update on a major win in a major case, and it's against a statewide ban on the purchase and possession of magazines. The state just made a huge mistake in their appeal that can get this entire case thrown out right here and now. So let's talk about what is happening. Now, really quick before we jump into this video, if you agree that all these state magazine bans are clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank one of the main sponsors and supporters of this channel, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry a Kershaw Iridium knife every single day for my EDC, and I cannot recommend their knives enough. And right now, if you go to their website and you order using the code ARMED40, you can get 40% off of your order. So head on over to Kershaw Knives to pick yourself up a quality EDC knife, and thank you again to Kershaw Knives for sponsoring and supporting this two-way content. As I mentioned in the intro, in this video, we're going to be discussing a huge win against a state magazine ban and also their permit to purchase. Oregon Measure 114, which put in place a statewide permit to purchase restriction and then also a magazine ban, was recently ruled unconstitutional and struck down in its entirety. The state court judge in that case issued a permanent injunction against Measure 114. Now, the state of Oregon is currently attempting to remove that permanent injunction through an appeals process, and again, they're asking for the Court of Appeals to override what the lower court said. However, the state of Oregon was required to file their expedited opening brief on May 31st, as ordered by the court. But shockingly, the state of Oregon failed or forgot to file their opening brief. This has now led to the Pro 2A side, the plaintiffs, filing for a motion to dismiss the entire appeal, the entire case, because the state of Oregon missed their filing deadline. The state of Oregon was actually the ones who were asking for expedited hearings and expedited opening briefs, but again, they forgot or just missed that deadline. This new motion to dismiss now sets up an opportunity for a final kind of home run attempt where the court, if they grant this motion, can essentially throw the entire appeal out now, and that would mean that the lower court's permanent injunction would be final. Now, the case we're going to be talking about in this video is called Arnold versus Kotek. The Arnold case is a state lawsuit that was helped and supported by GOA and SAF. This case challenges Oregon Measure 114 as a violation of the Oregon state constitution. Now, in the Arnold state case, there was a judge there, Judge Robert Rossio, in the Harney County Circuit Court, and Judge Rossio was a great judge who originally granted a TRO and then also a preliminary injunction, which was issued in this case and actually prevented Measure 114 from ever actually going into effect. Then on review of the final merits of the case, Judge Rossio issued his final decision, and in the case, he struck down the entire law there, finding that it was invalid. Now, in his order, Judge Rossio stated that this court is preventing the undue burden of ballot measure 114 from being imposed on current and prospective gun owners who have a right to lawfully possess firearms for the purpose of defending themselves and the state against imminent threats of harm. Judge Rossio ruled that Oregon Measure 114 was invalid under the state's constitution and must be struck down in its entirety, and so he issued a permanent injunction against Measure 114. But of course, the story does not end there. The state of Oregon then quickly filed an appeal up to the Court of Appeals seeking a reversal of what Judge Rossio said. They then asked the Oregon Court of Appeals to place a stay on that permanent injunction that was issued by Judge Rossio. The state of Oregon also asked for an expedited hearing and also expedited briefing schedules for the appeal if the court denied that stay. Well, the judges on review in that Court of Appeals did deny the stay request, so they sided against the state of Oregon. But they did decide to expedite the hearings and to issue a semi-expedited briefing schedule as requested by the state of Oregon. So in the order, the Court of Appeals set the Oregon opening brief to be due on May 31st. But Oregon just made a huge mistake, and they forgot to file their opening brief. This was something that I kind of vaguely remembered was supposed to happen on May 31st, and then today it kind of popped into my brain. I reached out to the attorney here in this case, and he said, yes, they were supposed to file that brief on May 31st. They failed to, and now action is being taken against the state of Oregon, and a request to dismiss the entire case has now been filed and is now being considered by the court. In this motion to dismiss filed by the plaintiffs, they argue that, however, May 31st, 2024 came and went, and defendants did not file their opening brief or a motion for an extension of time. Defendants also did not provide plaintiffs prior notice of their intent to orally request an extension of time. Here, this court fixed a briefing schedule at defendants' request. So again, keep in mind, the expedited briefing and the expedited timelines were asked for by Oregon. They go on to state that defendants have not and cannot provide an extraordinary circumstance justifying their failure to timely seek an extension of time from this court or timely file their opening brief. As such, defendants cannot and will not be able to provide a satisfactory response to the court, and the court can and should dismiss defendants' appeal for a want of prosecution. Plaintiffs anticipate that the defendants will complain that the trial court took too long to act on the joint motion to correct the transcript. However, defendants did not seek expedited consideration despite knowing that the judge there is a sole judge over 2 counties. So they're kind of fighting back against this argument about a delay in the transcript, saying, well, the state of Oregon knew that there was some sort of delay, there could be a delay, and they did not even ask the lower court to expedite the review and finalization of the transcript. So essentially, Oregon wanted the expedited briefings, but then they failed to actually meet the deadline. Oregon claims that maybe they missed the deadline because there were some errors down below or some issues with the lower court's transcript, but at the same time, they didn't notify anybody. They didn't seek an expedited kind of approval or a setting of that transcript by the lower court. They didn't notify the court. They didn't notify the plaintiffs here. They didn't seek an extension. Despite all those things, they kind of just sat on their hands and did nothing. Now, in the response, the state of Oregon argues that the motion to dismiss is invalid because on May 31st, the state of Oregon and one of their representatives called the court's office, and the court staff or someone on the staff told their attorney that they did not have to file the extension. They didn't have to get an extension. They didn't have to meet that filing deadline because, according to someone in the court, the briefing schedule was suspended. So the state of Oregon didn't even have to file for an extension. The state argues that that suspension of the briefing schedule was done by the court itself, maybe prior because of that lower court transcript issue. Now, the plaintiffs respond to Oregon's position by essentially pointing out that Oregon admitted in the response that they believed as of May 31st that their opening brief was due. They reached out to the court to see about filing an extension or at least getting oral approval of some sort of extension. And they believed that the brief was due on May 31st, and that's why they called the court. But based on the court staff telling them that they didn't have to, well, then they did nothing. Now, here in the response, the plaintiffs here state that plaintiffs, of course, were not party to defendant's telephone conversation with court staff and were not given any notice on the docket that the court had rescinded, suspended, told, or otherwise altered the briefing schedule it ordered at defendant's request. Absent a written modification to the court's order or notice to the plaintiffs assert that the court's order issued under its inherent authority modifies any contrary rule and remains in effect. This means defendant's brief is past due. So what's very interesting about this is the fact that if the court agrees with the plaintiffs here that the state of Oregon missed their deadline, that means that they can dismiss this entire appeal right here and now. They can grant the motion to dismiss and throw the case out. And if the appeal is thrown out, well, then the case is pretty much done for, and the lower court's permanent injunction will remain in place and will be final. Now, at the very least, I think what is likely going to happen here is that the plaintiffs also asked for the expedited briefing schedule that was requested by Oregon, pushed for by Oregon, was set by the court because Oregon wanted it. I think at the very least, that expedited briefing and hearing and all that will be thrown out. It would be very unfair for Oregon to get to essentially have all this extra time to file their opening brief, get all this additional time, and then also require still that the plaintiffs here would have to follow the initial deadline to file 21 days after May 31st, even though Oregon actually didn't even file their opening brief on May 31st. But kind of let's cross our fingers right now and hope that the Court of Appeals here finds that Oregon did in fact not follow the proper procedures. They should have gotten an extension maybe. They shouldn't have just got some sort of call to the court's office and say, yep, you're good to go. You don't have to do anything. Maybe they should have done some more. They should have followed the procedure, that they missed their deadline, and therefore this entire appeal should be thrown out. Now, speaking to the attorney in this case, they anticipate that the court, in fact, will rule on this issue sometime soon, maybe even today. So we could get some additional movement information here very soon. And also, speaking to them, I highly recommend that you guys go support the plaintiffs in this case. They gave me a link to donate to them, to their efforts. I will leave that down below in the pinned comment. So again, really crazy developments in this case because Oregon made a huge mistake and forgot to file their opening brief. If we get any more information, if anything else develops, I will let you guys know. Also, if you guys like this video, and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.